Hi, thank you so much for joining our webinar today. My name is Jessie Peterson. I'm the Director of Education here at SunRay Construction Solutions. SunRay secures $10 billion annually for GCs, subs, and suppliers. We're a national construction document service. Today's webinar is conducted by the incredible William Porter, a California construction lien law guru. Today's webinar topic is statutory construction releases. So without further ado, I'd like to introduce the fabulous and wonderful William Porter.
Wow, Jesse, such a nice introduction. Thank you very much. I don't know about the guru part, but I will do my best to let people know about these statutory construction releases. So we're going to be sliding along through these slides here. If anybody has any questions, there's my phone number, my email address, and Jesse's as well. And we do have an opportunity for questions today. But let's go through this. We're going to go 20 minutes, so it's going to be moving pretty quick. All right. Here's how you give us questions, and then we'll answer them at the end. Okay, did I do that too fast? Maybe I did. Okay, there's a chat box there. If you glance at it, you can probably figure it out pretty quick. It's on your screen. Okay, yeah, here's a legal disclaimer, because there's exceptions to everything. These rules, you get to a local judge, you never know what they're going to do. But we're going to talk about the broad rules in regard to these 4 releases and discuss how they're used. All right. Exceptions to these are pretty rare, but any local judge might do something unexpected. All right. Okay. So let's talk about the first release. So if you've completed your work and you've been, well, this is about the 4 types of releases. Okay, but they're going to depend on whether your work has been completed in part or in full, for that reason we have conditional releases and unconditional releases on progress payment and on final payment. Generally, you would use the conditional release in exchange for a check that is going to come or maybe has come and it hasn't necessarily cleared the bank. Okay, for all those circumstances, you would use a conditional release, because the condition is that the check is going to clear. And if it does clear, then the release becomes valid because the condition has been met. Now, the unconditional release is something you have to be much more careful of. It basically says, I unconditionally waive and release all my claims, all my rights to such things as mechanics liens, stop payment notices, and payment bond claims to the extent of the payment. Now, even if the check bounces, if you have given an unconditional release, you have indeed unconditionally released the claims availability on liens, stop notices, bond claims to the extent that you state in the release. Okay, so you have to be careful. I know a lot of people say, hey, sign this unconditional release and we'll give you a check. No, don't do that. You could sign the unconditional release and they could never give you the check at all. Yet the unconditional release would still be a valid release that the other party could use to block your availability of a mechanics lien or a stop payment notice or a payment bond claim. Okay, that's the general outlook. And we're going to be talking about statutes that are found in California Civil Code 8132 to 8138, noted at the bottom of this page. They're easy to look up. You could just probably punch into your Google Civil Code 8132 or 81. It's 8132, 8134, 36, and 38. Okay, and you can find the exact statutes if you want to look them over. All right. So the first one is if a progress payment is only promised or it has not yet cleared the bank. So if they want to have a release in exchange for a progress payment and the money has only been promised to you, where they say, send us the release and we'll send you a check, you can use this type of release. It's a conditional waiver and release on progress payments. Progress payments are, of course, when you have multiple payments on a regular basis, either based on the date, like once a month, or based on milestones, like accomplishing a certain amount on the job, and they will pay you a progress payment check. So then after the check clears, if they want, they can ask for an unconditional waiver and release on progress payment for the same amount. But really, you don't much need the unconditional waiver and release on progress payment form, because when the check clears, the condition has been met, and the conditional waiver and release on progress payment is enforceable because the check has cleared. Okay, this is the second one. If a progress payment has been paid in full and the check has cleared the bank, then what you would do is you would give an unconditional waiver and release on progress payment. Okay, and by the way, we're going to go over these forms in just a moment here, all right? The third one is if we're talking about final payment now. These last two are going to be on the final payment, and it's a similar concept. You would use the form of called a conditional waiver and release on final payment if it's your final payment on the project and the check has not yet cleared the bank, but you're hoping, of course, that it will. And if it does, then this could be used by the other party to the extent of the release to block your ability to get a mechanics lien, a stop payment notice, or a payment bond claim, because you have released your ability to make that claim because you have sent in this document and the check cleared. The fourth one is the most important. It's the one that owners and contractors are always looking for. And that is if a claimant has been paid in full, so you've been paid in full, and the check has cleared the bank. That means everything worked out. Pretty much if you have this subject to an exception that will note, or a category of exceptions that will note, basically this is the end of the job. You got paid in full, and you say, okay, I got paid in full. I have no complaints. No more money is owed. I'm going to give you an unconditional waiver and release on final payment. And it says, okay, thank you. I'm paid. Goodbye, or until the next project, we'll see you. And there's no issues, and you've been paid, and this kind of ends the whole thing. So this is the one that the owner and the GC like, because once you give one of these, there's no possibility of you bringing a successful claim for a mechanics lien, a stop payment notice, or a payment bond claim, except to the extent that we'll note as we go over the documents. Okay, here's one here. Conditional waiver and release on progress payment. So I have my little arrow here, and so we'll talk about this. Okay, identifying information, the name of the claimant, that's you. Okay, the name of the customer, that's who you're getting the check from. And then just to identify what project we're talking about, we put down the job, location, and the owner. And then what this does, it says right here, this document waives and releases lien, stop payment notice, and payment bond rights the claimant has for labor and service provided and equipment and materials delivered to the customer on this job through the through date, okay, of this document. Rights based upon labor or service provided or equipment or materials delivered pursuant to a written change order that has been fully executed by the parties prior to the date that this document is signed by the claimant are waived and released by this document unless listed as an exception below. Okay, that is the exception I was talking about. This document is effective only on the claimant's receipt of payment from the financial institution on which the following check is drawn. Basically, it's saying it's only effective if the check clears the bank. So you put here who's going to be making the check, filling it out, how much the amount of the check is, and who it's payable to. And then there's exceptions here. Retentions, because this is a on progress payment, so it's early on. Retentions aren't in here. Extras for which the claimant has not received payment. That's kind of a vague concept, but what I would say is that if you, like, here's the through date over here. So, and then here's the amount of the check. So what it's saying is that all the work I did through this through date, okay, and the materials I supplied are going to be released for this amount of the check, okay, and it's going to release all my claims through the date that you put here, okay. Now, there is an issue here on number 3 I would like to point out. The following progress payments, this is an exception, the following progress payments for which the claimant has previously given a conditional waiver and release but has not received payment. So what's going on here is that maybe the month before you gave a release. Let's say you gave a $20,000 release, And this particular one is going to be for $30,000. Okay, but you gave the $20,000 one last month. You still haven't gotten paid. You expected the check to come before this one was requested. So right here, you would write down the date of that release, and you would put $20,000 over here. Without this kind of a thing, there was a confusion before the statute was changed recently, because what would you put down here? If I'm going to release everything through this date, do I want to put down $30,000 like it would be for right here? But $20,000 is still owed. Maybe I should put 50 here, because 30 plus 20 is 50. So what we've done, and I was involved in the legislation to do this, happy to see, I'm glad I did it too, is that, oh, hey, I'm owed 30 right now, still 20,000 more from last month hasn't been paid. So you just note it right here. Okay, and then also I will say that an exception is contract rights. Okay, let's say you totally mess up with all this conditional waiver and release on progress payment. Let's say you give an unconditional and then the check bounces and you go, oh, shoot, I gave an unconditional. Then you can still sue on breach of contract, but you probably won't be able to sue for that amount on the whatever you released, let's say, on your conditional waiver and release on progress payment. But you still have your contract rights, so you sue for breach of contract, even though you can't sue on a mechanics lien, stop notice, or payment bond claim, which kind of says, hey, be sure to use the right form. Use a conditional when you don't have a check or the check has not cleared the bank. Okay, I spent a little bit more time on this one. The others are very similar. Now remember, this is the conditional on progress. The next one, I've just moved, blink of an eye, there it goes, change. Now we're on the conditional waiver and release. Let me see here, hold on a second. Conditional waiver and release on progress payment, conditional waiver and release on final payment. Okay, this is for the final payment, all right? So it's conditional though. It's much the same as before: name of claimant, name of customer, job location, owner, the maker of the check, the amount of the check, who it's payable to, and then here's an important exception for these. Okay, each form is a little bit different, but the document doesn't waive any of the following. Now, let's say you have disputed issues. Maybe it's regarding change orders. So right here, you would say, let's say $23,634 regarding change order number 6 dispute. You could put that there. So you could release everything. It's a conditional on final. You could release everything except for this disputed amount. So then if you have to file a lawsuit on, let's say, mechanics lien, stop notice, or a bond claim, after giving one of these things and they give you a check and it clears, you will still have the ability to put a lien or a stop notice or a bond claim on whatever you put down here as the disputed issue. Okay, so it reserves that issue. All right, let me see the next one. Here is an unconditional waiver and release on final payment. This is the granddaddy of them all, because it's the end of the job. It's final payment and it's unconditional. So you want to make sure that the check that you have has cleared the bank. And here's all the same identifying information. Here's the same language about releases. But look down here again. You can make exceptions down here. This document does not affect any of the following: if you have disputed claims for extras in the amount of whatever the amount is. And then this line here, this is a duplicate. This shouldn't be in here. We just revised it this morning. Sorry about that. That doesn't go there. I would like to say this though too. Let me see what we got here. Okay, we got the conditional waiver and release on progress payment, conditional waiver and release on final payment, unconditional waiver and release on progress payment. This means it's the check has cleared the bank, and we have the unconditional waiver and release on final payment. Yeah, all the unconditionals are for when the check has cleared the bank. Now these forms, generally they're on your screen right now as you see them. They're kind of sideways. Actually, it would be up and down, but when we present them up and down and try to fit them on a screen, the print gets much smaller. It's harder to read. So you can get these forms on our website, easy. It's just porterlaw.com. I think it was on the first screen, and you can use them. They're free. You just go on the screen and type into them, and you can use them. If you go on porterlaw.com and go on forms, you'll see a bunch of forms on there, and they're all free, and you can use them. Also, of course, if you have an account with SunRay, they'll take care of everything for you. And some of these things you want to use a service to do if you're not sure what you're doing and you want to be cautious about it and not make a mistake. You can have them do a lot of things like this. And there are many things, if you have good people in your organization, that they would be taking care of these things. And if they have any question, you could call your regular construction attorney, which you should have. And if you're in California, you can always call me. Anyway, though, the forms are free on our website, and SunRay can take care of you too. So let's see here. We have a few extra minutes. I'm wondering, Jesse, if we have any questions yet.
Well, first of all, Bill, you are incredible as always, so thank you. And you really are that guru, I promise. Now, we do have a couple of questions that came through. The first one, it says, on a preliminary notice, there are the conditional and unconditional releases that you talked about, but on a recorded lien, you have to provide that satisfaction to release the lien. Once the recorded satisfaction or once that is recorded, that is deemed unconditional. But what if the check bounces or there's a chargeback on that credit card after the fact? Is there any recourse to that?
Well, if I'm following it all, there was a lot of little parts in there.
Yes, it was.
Yeah. So if you give an unconditional waiver and release on final payment, and you think the check has cleared the bank, or there's a chargeback, probably if it was for the full amount, you probably would not be able to bring a mechanics lien, a stop notice, or a bond claim for anything that was covered by that unconditional waiver and release on final payment. And sometimes that is because other people rely on those things, like lenders, and they want to know that the property is lien free, and title insurance companies and all that. So it's a really important document that you have to be certain that the check has cleared the bank, and it can't be reversed. And there's some things to consider too, that okay, people often think that if the funds are wired into the account, or you get a cashier's check, that's the end of it, and it's over. But no, actually banks, they all have policies on these things, and those can often be reversed within a certain number of days by someone calling the bank and saying, hey, I'm the victim. They always, this is the key word. They say, I'm the victim of fraud. And then they'll either reverse it or they'll just freeze it. And the banks cooperate with each other on this so that less people get ripped off and they're not involved in litigation. So yeah, it's really important to be sure that if you're going to use an unconditional on final, that the check has cleared the bank. Now, there may be back charges and things like that come later, but a back charge that you get later isn't the same as you looking for money. It's whoever's above you, like the GC to a sub. The GC is looking for money from you, but it doesn't affect your lien rights. Now, also, there was a discussion in that question about mechanics liens. The mechanics lien is something that you would record at the county recorder, and it states the amount of money that you're owed and the date that it was owed from, and all that type of thing. If you were going to release those, let's say there's a satisfaction, then what you would have to do is you would have to record a release of mechanics lien, and this is something that SunRay certainly can take care of. And there's perhaps people in your office who can do that, but I would want to do that right. It has to be signed before a notary, and it's something that you should be cautious to do correctly. The same, of course, with recording a mechanics lien. So you have the mechanics lien, and then you have the release of mechanics lien, and both of them should be done with great care. I hope I answered that question.
I think you did. I think you got through it all. There's a lot to that. The next question that has come through, it says, when you send your preliminary notice, but the contract amount has now increased, do you have to do a new preliminary notice to reflect the new amount? And at what increased amount is that required?
Yeah, that's a good question. So if you look at the the technical language of the statute relating to preliminary notices, it doesn't say anything about increasing or issuing a new preliminary notice because let's say there's change orders or whatever and the price is increased. But I do think that there's something, because of some case law out there, that people should pay attention to. So, you know, it is anticipated that when you sign the preliminary notice, things can change, and there may be change orders. And I would say, as a rule of thumb, that that if you have some change orders and it pushes up the amount of your contract by more than like maybe 25% or something, and you're a sub and not the general contractor, because the general contractor and the owner, they know what's going on between themselves, but maybe you get a change order from the GC as a sub, and then you're going, well, I sent the preliminary notice to the owner and it only said $100,000, but now it's 125. Then maybe it would behoove you to take your preliminary notice, write amended on it, go to the amount, cross out the amount, put in a new amount, and then send it out to the owner, the general contractor, and the lender, the same way you would do with the preliminary notice, with a letter of courtesy that says, dear owner, lender, and GC, even though the civil code doesn't require that we amend preliminary notices, as a courtesy to you, I thought I would send you this so that you would know that because of change orders, the amount of our contract has increased by approximately $25,000, as noted in the attached. Thank you. If you have any questions, please call. Sincerely, and then you sign it. I mean, that's a courtesy thing to do, and based on case law that I've seen, I think that any judge that saw that would definitely say, hey, you've gone above and beyond. But as a technical matter, no, the statute doesn't say you need to amend your preliminary notice just because you had an increased contract. Just when you get to a point, maybe it's a good thing to do as a courtesy.
Okay, awesome. Well, thank you so much for that clarification. I do believe that's all the questions that have come through. If anyone does think of another question that wasn't addressed, please feel free to reach out and we'll be sure to answer any questions for you. Can you go to the next slide for us? Wonderful. Here are some of SunRay's resources to help you stay organized, know your deadlines, and secure your lien rights. So go ahead and scan that QR code to access these incredible resources. There's some really great information on there for you. Next slide, please. All right, our next webinar with Bill is going to be November 13th at 9 a.m. Pacific Standard Time. So please, if you can, join us. It is free to join. You can register at sunraynotice.com/education. We'd love to be able to see you there. That's going to be talking about getting paid faster with liens, bonds, and contracts. So it's going to be a really great webinar to learn from. All right, and then the next slide.
That'll be good. We'll be talking about how to do the mechanics lien process and go after payment bond claims and things in your contract that may be helpful to you. Next slide there.
Yeah.
There you go.
Wonderful. All right, and then here is, if you guys can, give us a quick review on Google. It takes about a minute of your time, but we really do appreciate any of the feedback you're able to provide to us. It always helps us better ourselves and grow and make the next webinars and seminars even better. So we really do appreciate it. And then if you could, with the go to the next slide for me, please.
Yeah,
all right,
there's
and that
my
is
number.
all Yep, please. Yep, there's all of Bill's contact information and mine as well. If you guys have any other questions, please feel free to reach out. Thank you so much for everyone who was able to attend. We hope to see you guys at our next webinar. Thank you again, Bill. You really are wonderful, and you really are that guru. I hope you all have a wonderful and beautiful sunny day. Thanks again, everyone.